Hello, and welcome to our webcast. I'm Amy Pendergrass with Moss Adams, and I'm going to get us started for today's session, Navigate Contracting Amid Healthcare Fraud Regulations. The presentation you're about to see isn't legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances. And now I'm going to play a brief video.
Welcome, and thanks for joining us. We're pleased to present another in our ongoing series of continuing professional education webcasts to help companies and individuals conquer challenges as they plan for what's next. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize how you both view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement or enter full screen mode using the controls at the top of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. You can download the group attendance sheet and a PDF copy of today's slides from the slide deck and handouts widget to the right of the slide view. You can ask our presenter questions during the webcast by typing a question in the Q&A window below the slide view and clicking Submit. We'll do our best to answer all questions during the presentation or follow up via email. If you experience technical difficulty during today's presentation, refresh your browser by hitting the F.
Today's webcast is eligible for 1.5 CPE credits for the National Association of State Boards of Accountancy. To qualify for these credits, you must attend for a minimum of 75 minutes and respond to at least 5 of the 6 polling questions. And now that we have our housekeeping items out of the way, I would like to hand it over to Lori to introduce our presenters.
Thank you, Amy. Thank you, everybody, for taking the time today to not only get an update on the healthcare fraud regulations related to contracting with referral sources, but also to hear about how to assess and complete audits or monitoring related to these different relationships. I have the privilege of introducing my co-presenters. I am Lori Laubach, partner with Moss Adams. I'm in charge of the healthcare regulatory compliance and healthcare internal audit. I work with clients on how to investigate, audit, develop monitoring tools, and ensure controls are in place related to mitigating risk. Presenting with me today are 3 experts, starting with Larry Vernaglia, who is a partner and healthcare lawyer with Foley, Lardner. Larry is the firm's industry team department chair, and over the years, Larry and I have spoken together several topics, including arrangements with referral sources. Larry represents hospitals, health systems, academic medical centers, and a variety of other healthcare providers on a number of issues. And I always enjoy the detailed perspective which Larry provides and how he and his firm address risk for clients. Next on our team is Jim Passey. He's the Vice President, Chief Audit and Compliance Officer with Honor Health, which is an integrated healthcare delivery system in the greater Phoenix area. Jim and I have also worked together over the years at his prior employers and also at AHIA with the HIA, and he's an experienced executive with over 30 years in the healthcare industry. He served in such areas as compliance, privacy, internal audit, and several other areas as a hospital administrator. In his current capacity, he assesses the different areas on referral source contracting within his organization to make sure that they have controls in place to mitigate risk. And then last but not least, Calvin. I am happy to introduce Calvin Swartley, who is a managing director at Moss Adams. Calvin and I have worked together on a variety of projects, and he has provided our clients with quality evaluation services over the years. Some of the projects we've worked on are due diligence to the client needing a process for contracting with referral relationships. So today we're going to go over some background, and we're going to not spend a lot of time on that, and this is not a course on the False Claim Act, Stark Law. You're all thinking goodness about that. But we're also going to talk a few things about some of the 2020 regulatory changes on the Stark Law, as well as address some of the fair market value things that we need to think about as we have arrangements with referral sources. And then there's a piece we're going to touch on the COVID-19 waivers and how to actually conduct physician arrangement and payment audits. This is we have some case examples and some discussion related to that. And Jim's going to share with us how he and his team have approached audit or monitoring of physician payments. So Amy, can you lead our participants through the first polling question?
Of course. So our first polling question is going to give us a feel for who's in our audience today. And it is, what type of organization do you represent? And you have the options there below. And we'll give you a few moments to respond. To participate, please click the button next to the answer you choose and hit submit. And we will leave this up. Oh, go ahead.
I was just going to say, as you complete this answer and you have any questions during this webinar, please make sure that you go into the Q&A and put that in there, and we'll try to address your question during other polling questions that happen during this session. And if we can't answer them during that, we will definitely work to answer those questions toward the end of our session as well.
All right, it looks like most people have had a chance to respond. I want to make sure everyone gets their CPE. All right, here are the results.
Thank you, Amy. It looks like we have a large percentage of hospital and health system and quite a few other organizations attending this. So today's topics are, like I said, a brief background related to these particular regulations, and as I mentioned, it's not a detailed session. Otherwise, we'd be here for several days and several hours going over every detail related to that. So first off, we're going to start off with the False Claim Act. Many participants on this call are probably familiar with the False Claim Act, and if any of us receive the OIG news or Department of Justice news, we continually see how the False Claim Act is used. This makes it important to keep the False Claim Act in mind as we work with physicians and contracting. It's a federal law that prohibits the submission of false claims to the government and payers that you know or should know are false or fraudulent. The false claim is an attempt to obtain payments by presenting false or misleading information. Putting aside this, the one big box on there is the box or circle is knowingly, and it has been broadly defined to include that actual knowledge, deliberate ignorance, or reckless disregard. Many of the government cases we've seen recently have resulted in False Claim Act and have been related to improper relationships between hospital and physicians or physician groups, as well as improper referrals. Another thing to keep in mind when we're looking at this, not only look at the Federal False Claim Act, but also the state False Claim Acts, and the fact that it does protect the whistleblowers against retaliation. Larry, any additional tidbits related to the False Claim Act you want to bring up?
You know, you're right to raise it because it's really the big stick in the hands of the regulators, and in particular the whistleblowers and the QTAM relator bar, because it provides the opportunity for a private attorney general to bring a claim on behalf of the government and get a share of the recovery. I'm sure many people know that. But it's also important to know that the rule doesn't just apply to services that were billed but not provided. It's interpreted extremely broadly, including liability for claims that were billed where there was a kickback or other improper financial relationship between the physician, let's say, and the hospital for purposes of this conversation. And I'd be remiss if I didn't remind people that probably the single greatest threat under the False Claims Act is the so-called reverse false claim, which is the improper retention of an overpayment once that's been identified. And under the Affordable Care Act, you have 60 days after identification to report and return it, or else it becomes a potential obligation triggering the False Claims Act. And I think that while there are a very small number of true bad guys out there in the healthcare world who would intentionally bill incorrectly, and glad they're all going to jail, a lot of innocent providers stumble into potential liability under the reverse false claims theory and the 60-day rule, far more than the true bad guys.
Great, thanks. Do you want to move us on to the Stark Law?
Sure. I'm happy to talk about some of the key fraud and abuse laws that are out there that go into this conversation that Lori teed up for us. The first of them is the physician self-referral or Stark Law. For those of you who are not as familiar with it, it's a civil law. It's a billing prohibition, really. It's a billing law that says that if there is a financial relationship between a physician and an immediate family member of that physician, then she can't refer so-called designated health services to an entity that would bill Medicare, and that entity can't bill Medicare for those designated health services unless an exception is met, and therefore those exceptions are mandatory under the Stark rule. There were new regulations published on December 2nd, 2020 that are still being understood and interpreted by the healthcare bar. I'm going to refer to them a few times, and we'll discuss them a little bit during our remarks today. The topics that you all have read about if you're in modern healthcare are things like the new value-based exceptions for value-based contracting models and risk arrangements, some new ability to provide cybersecurity technology to physicians and physician practices. But there are dozens of really important regulatory changes and interpretations that show up in these preambles. And so we're only going to touch the surface of them today, but we will cover a few of them here today. So they relate to both the Anti-Kickback Statute and the Stark Law, which I was just talking about. It's worth knowing in the compliance and audit arena that sometimes Stark applies and sometimes it doesn't. It doesn't apply unless there's a financial relationship with a physician or a physician's or immediate family member, and it doesn't apply unless that physician is referring designated health care services like inpatient, outpatient hospital services, lab, and things like that. But every now and then you find an arrangement where there's no physician around, so you don't have to worry about Stark, and you don't have to worry about Stark exceptions. As the slide notes, you're not just looking at financial arrangements where there's bags of cash, you're looking at any other items or service or benefit, and we're going to talk about a few of them in the case studies and examples that Moss Adams has prepared for us today. The second of the big two, well, maybe big three if you include the civil money penalties law, is the Anti-Kickback Statute. And that's a criminal law regulated by the Office of the Inspector General, the Department of Health and Human Services. And Lori has certainly had lots of occasions to be auditing around these topics. Did you want to mention some of the kinds of benefits that might trigger anti-kickback risk, Lori?
Yeah, definitely, Larry. Some of the things that we've seen in some investigations around the anti-kickback and other areas is that remuneration, particularly as it gets to things like gift cards and really looking at the gift card or the tickets. So, for example, an entity had given out movie tickets to different physicians during holidays or whatever you want to call it. But when you looked at the tickets they gave, it was actually a gift card and can be used for any purpose at the theater, like buying other things as well. So we were able to retract those gift cards and revise how we did that. So really looking at those gift cards and any other type of item that you're providing to it, make sure that you really understand what's being provided.
That's really good advice, Lori, and I think that there's a lot of times where some of those littler items aren't really given a lot of attention. And there is no de minimis exception under the Anti-Kickback Statute. Apparently a kickback of a penny is also a violation of the Anti-Kickback Statute if done with evil intent. But a lot of these show up in the area of sales and marketing, and probably the industry is paying greater attention to it now than they had before. I'll note that just last Thursday, the Department of Justice announced a significant settlement with Athena Health, the medical technology company, for $18.25 million. And that was a case where the allegations were that there were a number of benefits provided to physicians to induce them to purchase or transfer to the Athena software. And the kinds of benefits that were highlighted were all expense paid sporting, entertainment, recreational events, some of which included so-called bucket list trips to the Masters or the Kentucky Derby, as well as complimentary travel and luxury accommodations, meals, and alcohol. And it's an interesting case to think about because, you know, those are, you know, pretty extravagant seeming items. But if you think about what goes on in a lot of sales environments, many of them might be more familiar to you. I also think it's significant because this is another case where there was no referral for some separately covered service. Athena wasn't providing a billing service. They weren't billing Medicare. And we often hear when Lori and I are advising our clients, but we didn't refer any patients. Why would the AKS potentially be implicated. And their DOJ's press release in that settlement highlights that they see that the benefits of electronic health records, if they're to be realized, patients have to be confident that providers have selected the most effective system, not just the one paying the largest kickbacks. We might choose to debate that if we wanted to, but I wanted to at least call it out because it's a pretty current one, and it highlights the sales and marketing issues that I do struggle with sometimes. So where are we on this slide? We're talking about the Anti-Kickback Statute, but we're sort of weaving around a little bit between some of the safe harbors and exceptions. Under Stark, as I mentioned before, if you have a financial relationship with a physician, you must meet an exception in order to benefit from, in order to be able to bill Medicare for a designated health service. The Anti-Kickback Statute is broader, that it applies to more than just physician financial relationships, but it also has safe harbors which are optional. They're voluntary. If you meet one, then you're going to be protected from liability under the AKS, but you don't have to meet them. So we're going to go back and forth a little bit between them. I think that from an auditor's perspective, it's always better to attempt to meet the safe harbor, and you must meet the Anti-Kickback Statute. I wanted to point out a couple of the new, along the way, as I promised, some of the new regulatory exceptions, one of which I think will be really interesting for auditors to be thinking about is the new exception for so-called limited remuneration to a physician. And this allows, under Stark anyway, up to $5,000 per calendar year of payments to a physician, and that's going to be inflation adjusted, so long as those payments aren't determined in any manner that takes into account the volume or value of referrals or other business generated by the physician, that it's fair market value, that it's commercially reasonable, two key terms that Calvin's going to spend some time on in a minute, and that it doesn't violate the per click and percentage-based compensation formulas for leases of office space. It's a very interesting exception for those of us who've struggled with little footfalls in the Stark rule. What this allows you to do, though, is to find situations where sort of one-off deals or small purchases or payments, like you needed to get somebody to come in and cover the ER shift on Sunday and you didn't get a contract signed. Because except in very limited situations, like where there's a directed referral arrangement, the contract doesn't even need to be in writing to meet the limited remuneration exception. It's important to note that this is not a higher level non-monetary compensation exception, which some people initially thought it was going to be. It is still requiring some fair market value purchase of items or services. But from my perspective, this is going to be a lifesaver for a lot of small arrangements, including some that we might talk about today, Lori, such as coverage, part-time use of space, borrowing employees. And I'm really interested in Lori's perspective on how auditors should be thinking about some of these new rules as we proceed. Did you want to comment on that, Lori, or should I keep chugging along to save us on time?
Keep chugging along so we can stay on schedule, yeah.
All right.
Yeah, great.
Here I go. Another really important change in the rules that came out on December 2nd that everyone needs to know about is relating to the Anti-Kickback Statute's Personal Services and Management Contract Safe Harbor. This, like the sister regulation under Stark, the Personal Services Exception, is probably one of the most commonly used safe harbors to protect financial relationships with referral sources. And those of you who are wonks know that always the hardest part of the the Anti-Kickback Safe Harbor has been that the financial arrangement compensation had to have been set in advance in the aggregate. So you had to know at the beginning of the year how much money the contract was going to be. Impossible to do with an hourly contract or RVU-based contracts or, random services that were necessary. The formula might have been there. And that would have been okay for Stark, and it always was, but it was never okay to meet the safe harbor. Now, thanks to the OIG's regulatory sprint, it is now okay to have a safe harbored personal services management contract, so long as the methodology for determining the compensation is set in advance. So it harmonizes Stark and Anti-Kickback on these really critical contracts, and you should no longer see those caveats or risks relating to these arrangements because they can't meet the specifics of the Anti-Kickback Safe Harbor. I also want to make sure that we just touch upon the so-called ECRA law, which is the Eliminating Kickbacks in Recovery Act. It was designed to protect against abusive arrangements in the substance abuse and recovery environment, where you've heard horror stories about patient recruiters picking people up in limousines and driving them down to Florida and sticking them in a sober home and $25,000 fees getting paid to each other, bad stuff. And that's what they were targeting. And in many respects, it looks a lot like an anti-kickback statute, but more broadly than just applicable to the federal healthcare programs. It also has an unfortunate and probably unintentional trap in it that while it certainly applies to all the substance abuse treatment services that are out there, and that's what it was intended to do, the way the statute is written is it appears to apply to labs in general, whether they're doing substance abuse-related testing or urine tox screens, stuff like that, or not. There are similar safe harbors to the anti-kickback statute, but one important one that's worth at least noting, because we've all been struggling with it as lawyers, is it poses a particular challenge for employed sales agents of labs. You've probably heard your lawyers and consultants tell you, don't worry too much about your employed sales agents because you control them. But the special employee safe harbor under ECRA carves out of the protections, that is, does not protect them if the employee's payment varies by the number of individuals referred or the number of tests or procedures performed or the amount billed, which is very common in lab sales environments. So this is going to be one where we've been hoping now for a couple of years for some protections from the DOJ. We haven't received them yet. Before I wrap up and move on to our next polling question, I want to mention can't have a conversation with healthcare folks without talking about the COVID pandemic. And I've already covered opioids, so I've got the big two, Lori. But this one is related to COVID. And it's important to know that at the beginning of the pandemic, CMS issued some extremely helpful guidance to allow financial arrangements with physicians that would be carved out of stark liability. There are 3 key documents you should be aware of. There are, and we list them on the slides in a bit. There's a stark blanket waiver, which was issued on March 1st. There's an explanatory guidance in April. And the OIG issued a policy statement that said, if you meet those stark blanket waivers, we're not going to chase you for an AKS violation. These blanket waivers establish some really significant flexibility to make arrangements that are outside of the stark exceptions and AKS safe harbors to allow providers to respond to the COVID crisis, such as reducing physician rent, increasing physician compensation, offering loans below fair market value that may be repaid in cash or through services. It allows you to amend existing contracts to change compensation terms so long as you revert back at the end of the public health emergency to the original terms. Even though repayment could continue beyond the public health emergency, the extra payments have to stop. The OIG, as I said that they would not pursue deals that meet the blanket waivers, but I want to offer some caution that the OIG's policy statement really only applies to those arrangements that are specifically blessed under the blanket waivers. So if you have a financial arrangement which you needed to pay extra money because of COVID, but doesn't trigger stark, you might not be explicitly covered by the policy statement, but it would give you some good guidance about what they would or wouldn't be worried about. So if you're auditing transactions during the public health emergency or transactions that arose during the public health emergency afterwards, I think this is a great place to measure twice to see if you potentially met the waivers. There is some formalism to those waivers, so it's really important to do them with good counsel. But if you find yourself tripping up on an arrangement that looks like it might have come out of the crisis of the COVID pandemic, I want you to call Lori and chat about that as you design your audit tool. So let me turn it over to Amy for our next. Unless Lori, would you like to comment on this before we turn it over to Amy?
No, you answered all.
Or anybody else?
You talked about making sure you audit, so we'll hand it off to Amy.
All right.
All right, perfect. So our second polling question is, have you updated your policies and documentation around updates to fraud regulations? And your options are A, yes, B, not yet, C, we need to, or D, maybe.
So, Larry, I was wondering if you can answer one of our questions that came up during the...
I was just thinking about answering that, yeah. Do you want to ask it, or shall I summarize it?
Sure.
Go ahead.
Summarize it. Go ahead. We haven't practiced.
Yeah, so it's a good question that what if a charge is not in accordance with a CMS definition of a CPT chargeable claim? and it's billed to a non-insurance company. I think that she's talking about being billed to a patient as a patient amount. Are we triggering the False Claims Act? Well, if you're not dealing with federal payers, you're not technically dealing with the Federal False Claims Act. So that's good. If that patient ultimately submits it for reimbursement to Medicare or Medicaid, you might find yourself in a bit of a quicksand, but that's not what they're asking about. As Lori, you mentioned earlier, beware of state false claims acts, because state false claims acts often apply to third-party payers, and some of them may apply to individual self-pay cases too. Getting a little deeper into the weeds on her question, though, is how bad is it to be billing for something using a CPT code when you don't meet that definition? And that's one of those areas where the prosecutors will in fact say, hey, the description of the CPT code describes the service provided, and so that's the improper statement when you put down that CPT code that says what you did. When billing private parties, though, your real risk is having the Attorney General of the state come after you for a consumer protection violation, I would think. The best you can do in that sort of situation, if you're having a service that doesn't meet any CPT definition, because it's probably an uncovered service, is to have a really good description in a notice document that you provide to the patient saying, this is what you're getting and this is why I'm doing it. I'm curious about why you would need to use a CPT code anyway in such an arrangement. My hunch is that the question relates to some COVID-related services. Lori, did you have other thoughts on that, or maybe Jim or Calvin?
No, I think I think that you answered quite a bit of that. I think it's really going back and going to the original purpose of why they're doing that, and not using a CPT code inappropriately. It's pretty well described. So, Amy, do you want to show us the results? Looks like we got a maybe, a lot of maybes, and several that are saying not yet.
A lot of lawyers on this call.
Yes,
that's
a lot
the
of
lawyer's
lawyers.
answer,
So
maybe.
So now we're going to pass off the baton to Calvin to talk about fair market value, volume, and commercial reasonableness. Go ahead, Calvin.
Thank you, Lori. And Larry, in the consulting, we go with it depends, not maybe.
Right.
But wanted to highlight a couple of things for everyone. As Larry mentioned, with the changes that occurred in December of 2020. There's a lot to unpack with these three concepts that we have up today: fair market value, volume or value, and commercial reasonableness. A lot of new definitions within fair market value. We have three new definitions. Fair market value always has historically pointed to a term called general market value, and within general market value, we now have three new definitions. Commercial reasonableness also has a new definition. And then volume or value. So like I said, there's a lot to unpack here, a lot of things to talk about, but I'll try to go fairly quickly, and we can always follow up on some of these items. So fair market value is something that from an appraisal standpoint, from folks that do this kind of work, we always have historically started with what's the known standard out there for the term fair market value. And within Stark, there hasn't always been a clear definition. We've looked to appraisal organizations or the IRS as kind of a starting point, and then the general market value definition to move on from. As you can see here, the new definition still is very similar. It talks about value in an arm's length transaction. And the way the new regulations are broken out, there's a general definition for fair market value, and then it gets a little bit more specific and gets into fair market value for equipment rental and fair market value for office space. And some of the key components that are included in some of those other definitions when you start talking about equipment or rental space, it's not just the arm's length transaction, but it's also not taking into account the intended use. And again, it also highlights that it needs to be consistent with general market value. And then when we get to the actual office space, I think it's important to know that when you think about some of those ideas too, that it gets down into not taking into account the intended use, but also without adjustment to reflect the additional value the prospective lessee or lessor would attribute to the proximity or convenience to the lessor, where the lessor is a potential source of patient referrals to the lessee. So, a lot there to think about with respect to, as you're thinking about these assets or contractual obligations or other things, that we get to look at them very specifically, think about what a fair market value participant would think about with respect to this, and how to think about that irrespective of some of the nuances of the relationship. The other component of this that I highlighted obviously was general market value, and again, this has three definitions that go along with it, but in general, just to highlight, general market value is that price that an asset or service would bring as a result of bona fide bargaining between well-informed parties that are not in a position to generate business for each other. So, as Larry mentioned, as we're thinking about this, again, putting ourselves out in the marketplace where we've got something very specific. And then again, as I mentioned, and I feel like a broken record talking about that each of these kind of has three new components, general market value is broken down into key considerations of assets, compensation, and equipment or office space. So, similar to some of the items that we brought up before, each one of these highlights the bona fide bargaining between well-informed buyer and seller, and the idea that they're not in a position to generate business for one another. But it does try to break it down into these sort of key areas. Once we get through fair market value and general market value, we move on to commercial reasonableness. And this is another area where in the past, appraisers like myself haven't had just a completely defined term for commercially reasonable. There have been some past areas, court cases, those kinds of things that we point to highlight, how we might think about this. And that might come under, how does this represent the organizational value? Is it necessity? Does it fit? Is there a community benefit? Are there economic implications we should be thinking about? Is it really a needed service? Are there less expensive alternatives that could be thought about or entered into? And what are the financial impacts? As we think about commercial reasonableness, as we look at the actual relationships and such that are put together here, we like to see the agreement itself, a written agreement. What are the roles and responsibilities that are highlighted within the relationship that's being entered into, and what's the ability to perform? The new standards lay out that commercial reasonableness means that the particular arrangement furthers a legitimate business purpose of the parties to the arrangement and is sensible considering the characteristics of the parties, including things such as their size, their type, their scope, and their specialty. So some of those ideas that I brought up before that appraisers like myself would think about have been highlighted within this. And one of the other things that is of note that came out of this, that has been sort of a hot topic in the past, is, well, if I've entered into an arrangement and that arrangement does not actually generate a profit, is it commercially reasonable? And I think the new definitions and the new standard allow that you can at least look at this and consider some of those factors. Even if you are in a losing money position, does it create a benefit that makes this a commercially reasonable situation? So, again, kind of going back to one of the key items within this, it makes sense as a mean to accomplish a party's legitimate goals. So just wanted to highlight that area. And then this final concept to touch on is value or volume. And as you'll see in these two slides, I highlighted some of the wording updates here. So compensation considered to take into account the volume of value of refers or other business generated only if the formula used to calculate compensation to or from includes that value of referrals or other business generated as a variable. So that's one key consideration. This other portion of this also highlights that, takes into account the volume or value of referrals or other business generated only if the formula used to calculate it, the compensation includes that referral as a variable. And I know there's a lot sort of to digest between these two slides. One of the things that I saw with regards to this is a pretty easy and simple example to think about with regards to this. Take the example of a rental agreement for some space, maybe on a hospital facility. And if the space is being leased for some dollar amount per month, but then includes a provision that would give discounts or reduction in that rent based on each diagnostic test ordered through the hospital, this would probably fail the objective test. But on the flip side of that, one of the other things to consider with this is that there could be production bonuses or other aspects of this that would not fail the test. So value or volume is definitely one that we're going to be taking a deeper dive into here in the near future to make sure we've got a good sense of the direction this is going. Larry, I don't know if you've got any additional comments that you want to highlight on any of these three, or especially the last one, value or volume.
Well, yeah, I do have a few things. These are really important topics that are now being referred to by CMS and OIG as the big three: fair market value, volume or value, and commercial reasonableness. I'm finding that we're still struggling with how to read all of this collectively. They've certainly introduced some greater level of facts and circumstances analysis. So, for example, when you were right to call out that the commercial reasonableness definition looks to the specific characteristics of the parties, so size, type, scope, and specialty. I'm curious about whether that means, whether that complicates your commercial reasonableness opinions that you would give historically. I also think that another interesting detail that you mentioned in regards to leasing, that they kept in the new rule the without adjustment to reflect the additional value of the proximity or convenience. But CMS removed from the definition a statement that rental payments don't take into account intended use if it takes into account costs incurred by the landlord in upgrading the property. We were always happy with that. I was always happy with that parenthetical. And I think that some people might be confused about why they removed that. And I don't think they removed it to imply that those build-outs are somehow problematic. In fact, I think that they were worried that it was causing confusion because they never believed that those build-outs were going to be problematic. So it's worth noting that, I would say. Should we move on to our next polling question?
Yes, I think we should.
All right, so our next polling question is, which of the following does not have a new definition? A, commercial reasonableness, B, pay to play, C, value or volume, D, fair market value. And as a reminder, if you would like to receive CPE credit, you will need to respond to at least 5 of the 6 polling questions. And for those of you that would like a copy of today's slides, you can download them now from your console. And we will be sending them out tomorrow along with the recording of the webcast as well.
While we're waiting for the results, I'm curious, Calvin, about your thoughts on volume or value in particular. One of the pieces I thought was real interesting was the introduction of the notion of a variable or a factor, and which has to be positively correlated with remuneration. Have you given some thought to how to evaluate contracts that don't have such a variable in it, but sort of indirectly increase compensation if it based on additional referrals? I can tell you that I haven't come to my own conclusion on that yet.
Ooh. and that might be another one that's probably a full nother conversation at another time. But I agree with you, Larry, that it's an idea that I think would have to be looked at. And as I said before at the beginning, when I said it depends, a lot of these are facts and circumstances type-based decisions and analyses, and I think we'd have to look out to the marketplace and obviously see if others are able to do similar types of contracts, what the implications of those contracts might be, and then how to think about that from the perspective of meeting not only the value or volume criteria, but the fair market value criteria, and then whether that needs to fall into the commercial reasonableness bucket also. So there's a lot to unpack there, I believe.
That's a good thought. Got our results.
So I think
So Calvin,
yep.
Do you want to share what you think?
So there is not a definition for pay to play within the new regulations. That would be the correct answer. And it looks like about half of the people got that right.
Good news. Great. So thank you for answering the questions, everybody. We're going to move on to some case examples and have a little bit of discussion and make sure we have time for how to complete audits. So let me move on. For our first case study is related to a hospital where the CFO has come on board, and they have some concerns about the compensation model. It's got greater than 90% of the national levels, as well as he says there's no minimum work RVU. He's seen that across multiple arrangements. He also looked at some providers' resulting work RVUs and had some concerns about how it's being calculated. They've implemented a compensation policy. That compensation policy has a reference to fair market value, but not sure that it's actually being followed or can't find the evidence related to the different arrangements. Then they're also concerned about some director payments, not just one particular provider, but multiple providers on receiving additional money or being paid money during the year for director services, but there's no documentation such as timesheets or any type of invoicing or anything like that. So with that, I would wanted to talk, Calvin present some of the concerns from a valuation perspective, and then Larry, maybe you can talk about some of the legal issues. Calvin?
Thanks, Laurie. So yeah, I think this is a great case study, and definitely has some things to think about. And obviously I would go back to again the facts and circumstances that we're looking at here, to come in and look at this from a fair market value perspective. One of the first things we would want to see and understand is any type of agreement or arrangement that has been established. Obviously, there should be some documentation that spells out the roles and responsibilities, and we'd want to see that. The ability to track or have some history as to how the relationship has been working to this point would be really important for us to see. And I think one of the things that you bring up is this compensation in excess of 90%. Obviously, there are a lot of studies or surveys out there that look at, say, compensation arrangements, and they'll show you the average, the median, the third quartile, or the 90th percentile level. Well, those don't tell you the outliers, the ones that are all the way at 100%. Someone has to be at the highest level. It also can't tell you some of the unique facts and circumstances of things that are going on within the relationship. So just because compensation is in excess of 90%, that wouldn't always trigger something for me to look at it, but I'd want to make sure that we understood exactly what was going on. And then I'd also go back to some of those commercial reasonableness factors that I talked about before, related to why was this relationship established? What's the purpose of it? What are the outcomes that are expected? Those kinds of things that would go along with it. Larry, I don't know if you've got any additional comments that you might think about with respect to this.
Well, I think that you're exactly right, that where there's a 90% threshold, that means that 10% of compensation is higher than that. And so there is no such rule that says if you exceed some percentage of the salary surveys, you're in trouble. In fact, the closest we ever had to that was back in the day, CMS used to have, or HCFA, I should say, used to have a safe harbor for physician comp that if you came at 50% of the average of 2 salary surveys or something like that, you'd be okay. CMS pulled that regulation out of the books because they thought it was stifling competition and compensation of being used improperly. So there is no such rule on the 90% thing, but it does if you have a hospital or other organization with a salary compensation policy. Obviously, that's triggered. I will point out to you as well that in that new preamble for the Stark rules from December, CMS was talking about its notion of fair market value, and particularly compensation for physician services, may not always align with published valuation data compilations like salary surveys. And they write, in other words, the rate of compensation set forth in a salary survey may not always be identical to the worth of a particular physician's services. So it could be more or it could be less. And I think it's worth noting that they do say sometimes hey, it could be less. So I consider the salary surveys to be a data point, but not the end of the conversation for physician comp. Lori, did you have any additional thoughts on that?
Well, from an auditing perspective, I would want to make sure that if they do go through and look at what I call rock star physicians, I would make sure that there's some documentation about that decision either in your compensation committee minutes or somehow in the file related to the physician, so that if you do have to demonstrate how you came to that number, it's easy to look at if you don't have a fair market value opinion.
Well, and Laura, I don't think it necessarily needs to only be physicians. I know I've had a case where we had a nurse practitioner in the state of Alaska in a very rural setting where the cost of living was more than 200% higher than most metropolitan areas. And to attract and bring someone in to fill that position was very expensive. And would have blown this 90% threshold out of the water in terms of still getting to a point where we felt comfortable with a fair market value assessment that was in excess of what you normally see in a study or those kinds of things.
About downstream referrals, tracking that, Larry, is there any concern with that, or just some quick tips for people?
You know, I think this is a sort of a hairy area because you create sort of bad seeming evidence if you're thinking about downstream referrals while setting compensation arrangements. So I certainly would encourage people not to do that. It's not illegal to do that, but it would be illegal if you're taking into account the referral volume in establishing the payments to the physician or other referral source. So certainly the better plan is to at least separate those conversations and not consider them in the same boat. But I always thought that it's irrational for someone to say that a hospital should be ramping up hiring in a certain service line without knowing what kind of work is going to be done there. Will that mean that they need to hire more nurses too, or schedule more OR time? So it's foolish to think that you can't at all pay attention to how much volume might come from a new hire, let's say. You just can't use that as a basis for calculating compensation.
Anything about the contribution margin?
Well, that's the same sort of point, I think. While it's okay, and CMS has gone out of its way to say it doesn't matter if you lose money on a particular physician. It doesn't necessarily mean that transaction is not commercially reasonable. Calvin, you were right to point that out. But at the same time, if you are using contribution margin to set your physician's compensation, I think you're going to be buying yourself a lot more trouble than it's worth.
You know, just some thoughts on auditing for this case. I think that some things I was just going to mention on this slide to keep us moving along is just make sure that you're looking at all the payments that are being paid to these particular providers. And also the really time records or logs are really not specifically stated as required in the law or regulations. but you do need to demonstrate the validity of the services rendered as it compares to what you've actually written in the responsibilities for the particular position, or just what are the services that they're doing to the detail that you'll understand that they're performing those requirements for the agreement. So it's important, and we see from an industry practice that many organizations put time and effort requirements in place, timing, how long it takes to get those put into place as well. So we definitely would want to do that. The other thing I wanted to point out here is maximum hours per month. Have some clients or agreements are written that way, but if they exceed those maximum hours per month, what is the actual maximum hours per year? Does it go over that fair market value and other things like that? So consider those items as you dig into auditing and investigating this. To move us to our next case study, and that is a board meeting by a hospital, and the corporate secretary is concerned. Mainly had some concerns about tax and how do you report this for tax, but once you start digging into the facts, you'll find that there's a board meeting where it includes some specialty trips, deep fishing, to actually bringing their spouse and paying for their travel, hotel, golf, fishing, etc. Two of the members of the board are physicians. They're practicing independent orthopedic surgeons. They did receive a total of, which seems pretty low compared to what we just listed as items, but $4,500 related to attending this board meeting. The other thing to point out is that this is the third year in a row for this annual meeting, and they also, the board members, contribute quite a bit to the organization as personal donations to, quote, they think it actually covers that. And so just some discussion points related to this. Larry, what's your thoughts around some of the risk areas related to payment to the board and committee meeting members, and even touch on that $4,500 in current rules?
Sure. Well, let me start with the narrow and then blow it up a bit. So, this is exactly what the limited remuneration to a physician exception was for, and how convenient that the value of it was $4,500. But beware that this is an exception which is prospective only. So if you're auditing, 2019, 2020 claims, you won't be able to take advantage of that. And I still recommend in those situations having an engagement letter with the physicians and showing that there is a service that's being provided by the physician to the organization, and the in-kind benefits that might accrue with it are part of the fair market value compensation for it. But since you asked me the general question of risk, Lori, I couldn't help but also point out that sometimes the risks here are more so in the reputational area, in that when word gets out that the board is having a luxury trip on Sanibel Island while they're doing pay cuts for line staff, the reputational harm is worse than any hazard I could dream up under the Stark Law. Do you agree?
I definitely agree on that. The reputation and the fact that there's money being raised, but then it's going to the benefit of them as well, is kind of a very much a reputational item. I agree with the engagement.
But for purposes, and I think you're. I'm sorry. Go ahead. I cut you off.
Go ahead.
I agree with the engagement letter too, because that whole limited remuneration exception is not a planning tool. It is a defense. It's much too risky, I think, to rely on that and assume, it'll always be fine, because you might exceed $5,000 a year, or maybe the payment terms won't be that clear. So it's always better to rely on the personal services exception or fair market value exceptions, relying on some nice written document that ties it all together.
I think the other part about the $5,000 is you can't ignore the total compensation for a physician. They have other arrangements as well, so you need to add up all those, make sure that fair market value and other risks are assessed related to that, and looking at all of the agreements as well. Yeah.
Another approach to these is that there's always some additional defensive arguments that these are payments that are unrelated to healthcare services, and so there are some defenses that kick around about that too, but they're much harder to rely on, and they're certainly not from an auditing perspective.
I think it's important, as Larry said, when you start to do an audit of this, is to look at beyond just what is being paid for accounts payable to a physician or physician group itself, but also look at those board meetings and committees and find out what's happening, who's actually attending those, look in the general ledger detail as well as look at your P-card transactions as well. So definitely need to dig into that and make sure we understand that before they happen, not after they've happened, and so you don't have to do some corrections or changes to what do any type of payback of any sort. So really digging into that would be important. And we did get a really nice comment from one of our attendees saying that we've also been surprised about how these physician director contracts don't have consistent maxing of hours for directorships. So I'm not the only one who gets concerned about that when we do our audits. So we're going to go into non-monetary comp. And Larry, do you want to walk through this case example and then just some of the risk and then?
Yeah, glad to. And I think non-monetary comp situations are really good opportunities for auditing, and they're tough for a lot of reasons that this hypo will get us to. So in this situation, the hospital has been meeting with surgeons for the last 5 years to discuss how to support the hospital and a new surgery suite. They've been holding quarterly dinners for $1,000 or more. Each surgeon also got a lovely fleece jacket with the hospital's name and logo on it. Currently, the surgeons are using the surgery rooms for current patients and are noted as the operating physician on the claim forms. And there is a database for non-monetary comp, which is terrific, though it's a manual process for entering it. So we can want to talk about how you might audit this one, Lori?
Yeah, definitely. You know, one of the things, this is a very hot topic on a lot of the radar, although it's such a small dollar for many people on the audience. I just want to let you know that non-monetary comp is set each year based on a price index. And last year it was you had up to $423 to spend, to use for non-monetary comp, whereas this year it's $429. There is a separation too, as well as for medical staff incidental benefits. One of the things I think are helpful to do some auditing of this is really digging into not just, how do we test the transactions, but also understanding how the database is maintained, who is actually keeping it up to date, and who actually has ability to process like an order of donuts or something like that. I'm just saying that out of jokingly, but really making sure you understand. For example, we had a client who had an assistant who had a P card because the executive was too busy. And when we did the actual selection of P cards, we were looking only for executives, and we probably should have been including all the executive assistants or any P cards that might be related to that. So really digging into those purchasing cards and then test out those, as well as we mentioned earlier, gifts to the medical staff, making sure that any gifts are given to a physician group, that they understand that it's not just equally split. If it's, for example, a painting or something like that, that one would be equally tracked to each of the physicians, not separated equally. And then making sure what's the process if NMC, non-monetary comp, is actually reaching the level of $429 for the year, and you don't have a process in place where the executive must check the NMC before they go ahead and have that dinner with that physician. And suddenly you're over that limit, and you have to get something back or pay back before the end, rectify it before the end of the year, or if it's in prior years, how you may have to go back and correct claims that were submitted related to this, as well as the revenue. Moving on to our polling question. Amy, would you like to walk everybody through that?
Sure. Our fourth polling question, does your organization review or audit the non-monetary compensation? A, yes, B, unsure, C, we probably will now, or D, need to inquire.
And one of the things I was going to mention about non-monetary comp that's very interesting is that when we did help a client try to self-disclose some of the revenue that was produced because of going over the non-monetary comp, we had to go back and really dig. This happens on any type of situation, is going back and figure out who was the referring provider, but also who was the admitting physician or the surgical physician, or the person who was performing the surgery, because that would indicate if we had any type of revenue or payment related to that service for that provider we have of question. Any hints on that as well, Larry, that you might bring out?
Well, I agree that these are some of the trickier areas to audit. Your point is well taken, because what you're doing is you're trying to dig out the designated health service revenue from Medicare, and how much of it do you actually attribute to the violation. One of the things you and I have discussed is how long does that violation run? So if you have $430 instead of $429 of non-monetary comp, and if the physician won't give the money back, how long does the period of disallowance end where Medicare referrals are bad? And the answer that we use is that it runs through the end of the calendar year. So the number will reset again on January 1st. And in my experience, CMS is amenable to that point of view, which is helpful, because if you're 429, if you exceed your 429 in December, you've got 30 days to calculate, and if you exceed it in January, you have a whole year. So that's certainly one of the most important factors to try to to legitimately minimize the risk of and what your self-referral disclosure protocol will look like. One of the things I've seen in a number of these audits is that even when you have those manual systems, the way physicians are recorded is sometimes different. So you'll have Dr. John Smith and Dr. John Q. Smith, and they'll each get $429. Well, guess what? It's the same guy. Because the system didn't identify that you've now entered the same doc twice. And it's a human error, but that human error is below stark because it's not an intent-based statute.
Good point, Larry. Not using particular identifiers besides name could definitely trigger that as being a problem if you have a custom database.
Or NPI, right? Yeah, right.
Okay. So it looks like we have some folks that need to inquire and find out about how they're auditing that, or even how they're tracking the non-monetary. So with that, we have one last case study, and this is really around the COVID and related to the fact that we have a physician who started and has an income guarantee. And if we go through the facts, and just a quick start, is that the physician agreement includes an income guarantee for this dermatologist during the first year after moving to this particular town. And this is during the time frame also where we saw a closure of elective surgery. So they agreed to extend that income guarantee by another year. And now we've been asked to look at that final reconciliation of payments in the first quarter of 2022. So what are some of the issues that we might see related to this, Larry and Calvin?
I'm happy to kick it off, Lori, if you like. This is one where we're talking. This is squarely in the middle of those stark blanket waivers that I introduced at the beginning of the session. And while they are extremely helpful, and I think CMS did a heck of a good job of pulling them together, there are a few traps in there, so be careful. The first of the traps is that the blanket waivers are not for so-called indirect compensation arrangements, only direct. So it's important to evaluate if, in a relationship like this, the payment is indirect to the physician, or is it somehow triggered as a direct financial relationship under the so-called stand in the shoes rule. The second thing I want to note is that in the CMS blanket waiver explanatory guidance that we mentioned before, CMS said you can't extend an income guarantee period because the physician will have already relocated for the recruitment. So you're not getting something else for your money. So that would suggest that this particular arrangement wouldn't squarely meet what CMS wanted to see in the blanket waivers. Though in a situation like this, you still could have used other waivers, such as you could have entered into a new loan arrangement or a new compensation arrangement to help out that physician. So it's really unfortunate that this is an area where, again, good organizations could get trapped or caught because of the technicalities of Stark. Calvin, did you have some thoughts on it too?
I think one of the things I think is important on this slide, and then we'll move on, is one of the strategic is one of the words I got out of what you just said, Larry. And as we look at last year and what happened, need to go back and look at what those arrangements were where we brought on providers and physicians during the year during this period to see, say, in those waivers, strategically look at those arrangements as well. So with that, we're going to go ahead and hand off to Jim. Jim, I'll let you talk about how we might want to audit some of this.
All right. Thanks, Lori. So we're going to switch gears a little bit and talk about actually rolling up our sleeves and auditing payments to physicians. Now, given the complexities that Larry and Calvin have just outlined, there's a lot of moving parts here with a lot of different people playing different roles. So sometimes that makes this process somewhat prone to error. So as such, having a good routine auditing process is really critical to avoiding compliance risk with physician payments. So let's kick off this first section here with a polling question. Amy, do you want to help us with that?
All right, our fifth polling question. Do you have a current program for auditing, monitoring physician arrangements, and payment? A, we audit annually. B, we monitor quarterly. C, we do not have a standard audit monitoring program for this area. D, unsure, or E, not applicable. And we will leave this up for a few moments to let everyone respond. And once you have completed all CPE requirements, you will be able to download a PDF of your certificate from the CPE progress window.
So while we're waiting for people to finish up the poll, I should note that there are a lot of different ways that you can audit physician payments. So we're only going to provide some tools and some ideas to get you started, but you'll want to customize whatever process you use to your organizational needs. So we're really going to look at kind of framework that can be applied to a lot of different types of physician arrangements. So it looks like we're at about 82%.
All right, here you go.
Okay. So it looks like we kind of have an even split across the board. We've got between 15 and 25% responses of a variety of different approaches, and there is no one single standard per se. But I would emphasize this is an area that you really want to have some kind of a routine audit process in place, because what I have found in my experience is it's remarkable how you can do an audit, implement corrective action, and then discover a year later that some of that corrective action kind of fell apart and you're no longer operating the way you hoped you would be. So I think the first main task is going to be defining the scope of your audit. So I really strongly encourage people to spend time getting this stage of the process right, as an incorrect audit scope can result in more work down the road, or it can cause you to start your audit or have to restart it over again. So there's definitely a time and effort resource involved in this process, and you'll want to be as efficient as possible. So you'll want to start with a list of attributes that you're going to look at in your audit. This list of attributes should include very specific regulatory requirements related to physician payments, and Larry and Calvin have touched on a number of these already. We're going to offer a suggested list in this presentation for your consideration, but by all means you'll want to customize it to your unique physician arrangements and your unique environment. One important consideration to make is if you haven't conducted an audit or review of physician payments before, or if you haven't conducted one recently, you really don't know exactly what you're going to find, and given the high-risk compliance aspect of this process, you might consider speaking with your legal team to ask them if this is a review that might need to be placed under legal privilege, just to be safe. Another important aspect of your audit is defining the scope of coverage. So what types of physician arrangements do you want to audit? There are a myriad of different types of arrangements, each with a unique approach to how you might evaluate them. So decide up front what types of arrangements you'll be reviewing. Also, span of coverage is important. Will you be auditing physician payments at one site or across multiple sites if your organization has numerous divisions? Another key factor is how many payments you choose to audit. If you have resources to audit all physician payments within a given location or time frame, that's great. Many organizations don't have those kinds of resources, so you probably want to sample a number of payments. How you choose to sample is also important, whether you opt to conduct a purely random sample or if you choose to judgmentally sample your payments. There's pros and cons to either approach. Judgmental sampling may help you to focus on more problematic areas, whereas random sampling may be more representative of your performance across the entire universe of payments. It's important to be consistent with your sampling methodology so that trending will become easily apparent if you choose to perform this audit routinely as part of your ongoing monitoring process. You'll also need to decide what time frame you choose to audit. This decision will also be based on how many physician payments your organization makes. If you don't make many, then maybe you could go back a year. If you're making hundreds of payments every month, then maybe sampling from a single quarter is more appropriate. And one thing I encourage organizations to do when considering your sample is to first run your data. You might be surprised at the number of payments that you have made to physicians, so that could be very helpful in determining how you approach your audit. So in the interest of time, I'm not going to go through these in a lot of detail. You will have access to the slides. You can go into these in more depth in your own organizations. But just to cover what attributes you might look at, and certainly by all means add more attributes specific to your own needs. But first off, does a written agreement exist defining the services and compensation? We've talked a little bit about this idea of you need to have a written arrangement that clearly spells out the services that will be rendered and the amount that would be compensated. Another element, is the written agreement current? Meaning, if you're paying a physician for a certain service, is the service they're providing, does it fit within that agreement time period? Another aspect is the nature of the agreement, an employment relationship or an independent contractor relationship. There's some interesting nuances between those two relations. Is the agreement signed by all appropriate parties? Obviously, if you have a contract that's not signed by all of the appropriate parties, then it really isn't a valid agreement. It's a partially executed agreement, and it would be difficult for you to justify using that agreement for paying physicians. So you want to make sure that it's signed by all the parties and that it's signed on time. Sometimes this concept of a late signature can be problematic if the contract is effective on January 1 and yet we have the signatures are in March and April or May or beyond. It doesn't really become effective or executable until everybody signs it, and that any differential between the effective date and the signature date can create a little bit of liability for you. Is the agreement effective period for at least 1 year? General Stark requirements really look at that 1 year period to ensure that it's a long-term bona fide agreement. There are exceptions to that, but generally you want to make sure that your agreements are about 1 year. Are the physician's time or services reported or invoiced according to the agreement language? Sometimes you actually have embedded in your contract a timesheet or an invoice or some kind of formal document. Is the physician using that form or format to submit their time? And is the payment consistent with the agreement language? There are a myriad of different ways that payments to physicians are calculated. It could be an hourly rate, a daily rate, a per service rate, etc. You want to make sure that the payment is consistent with how it's outlined in the contract. And frankly, that those calculations are made. I'm often surprised to see that the individual who submitted the invoice got the invoice right and the rate was right, but then they just calculated it incorrectly and it ended up in being an incorrect payment. So you want to make sure that those calculations are right. Is the timesheet and invoice documentation adequate to support the payment? One of the case studies we used earlier was a situation where physicians were being paid for services, presumably, but there was no documentation to really support what specific services were actually being rendered. So you want to make sure that that's all there. Were the agreement and any amendments loaded into the contract's database? Best practice is that you have all of this information together in a central repository so that obviously when performing your audit, you've got everything you need at your fingertips. But perhaps more importantly, if you get audited by an outside entity, such as the government, you want to make sure that you have ready access to that. If there's delays or if you're stumbling to try and scramble to put that information together, it's not going to really bode well for your case to say that you've really got a sound physician arrangements process in place. Was the payment request approved by someone in management? Given the level of risk with these types of payments, you really want to make sure that someone in a management position is actually reviewing these and approving these payments, and it's not a clerical person, or it's not just being rubber stamped and going without management really ever seeing it. Does documentation exist that a fair market value analysis was conducted? We talked a little bit about the importance of the fair market value analysis. So now that we've discussed some of the audit attributes, let's talk about the first step of the audit itself, which is collecting your universe of payments. So first, you'll want to obtain a list of all the payments made to either a physician or a medical group for the time period being audited. We discussed earlier that you may actually want to do that as part of your scope development to make sure that your audit scope is correctly positioned. The list would normally come from your accounts payable departments for physicians who are acting as independent contractors. The data request should include such things as pay date, payee name, amount paid, contract number if that's available in your system, and a description of the services or the supporting documents. Usually when a payment is made, accounts payable will expect to have some kind of supporting documents, so it's handy to have those there. One challenge that sometimes presents itself is that your AP department may not be coding payments to physicians in a way that makes it easy to find. So if that's the case, you may want to ask them to start flagging payments made to physicians or medical groups in order to make this data run a little easier. Making physician payments easy to identify has numerous benefits in addition to the auditing process itself. You will specifically want to avoid the temptation of pulling your universe from a list of physician contracts. We talked about the very first question or the very first audit attribute in our list was to validate that a contract exists for the payment in question. If you pull your sample only from a list of physician contracts, you'll miss identifying any payments for which a contract doesn't exist. And of course, that's probably going to be one of your highest risk areas. So once you've identified your universe and chosen your sample, you'll now want to collect your supporting documents by matching up each payment with its associated contract. And if you find a payment that does not correspond with a contract, you're going to want to seek some advice from legal counsel or your compliance department on next steps, as that might be a red flag. There are a few exceptions allowable where a payment to a physician doesn't need a contract, but again, you'll want to make sure that you confirm that with the appropriate parties. So once you've identified your universe, you've chosen your sample, you've collected all your supporting information, you'll now want to start comparing each payment against its associated contract, reviewing it against each of those attributes that we talked about earlier. This is where the real meat of the audit is performed. As you do this, keep your findings in an audit log for reporting and tracking. To help your process owners focus on areas of concern, you might consider creating metrics around which audit questions in your attribute set had the most frequent errors or concerns, and this will help you to prioritize your corrective actions afterwards. Consider reviewing all findings with legal counsel experienced in this area. Counsel may be able to confirm that regulatory exceptions may apply that make certain findings acceptable. The Stark Law and Anti-Kickback Statute have numerous nuances that may need to be considered before reporting your findings in a formal format. This audit makes for a great monitoring tool which you can apply consistently over time to evaluate your ongoing performance. And don't assume that past identified errors were completely corrected or sustained over time. This is an area that in my experience I've seen consistently. So one interesting caveat to be mindful of is this concept of a physician being a referral source. And Larry and Calvin and Lori kind of talked a little bit about situations like this. If a physician doesn't refer patients to your entity, it may not fall under the Stark Law. So some examples might include physicians without privileges to admit inpatients or who don't refer outpatients to your organization. Maybe they don't practice in your direct service area, or they're just not around or in that vicinity. Also physicians who only provide continuing education seminars, but they don't reside in your market area. So if you invite a physician from across the country to provide CMEs to your medical staff, they likely wouldn't be considered a referral source. And then we talked a little bit about the case study of the physicians being on the board. You may have physicians who serve on your board of directors, but they're retired. They're not in practice. They don't refer any patients. So you may want to consult with legal or compliance departments on other possible exceptions when it comes to referral sources. I would also echo some of Larry's comments about working with your legal resources to make sure there aren't other exceptions, including those that are made allowable during the public health emergency that you should be taking into consideration. And one final consideration, one type of audit that you might consider performing is a physician lease audit. This type of audit is a little different from other physician arrangements because this is where you're actually receiving money from the physician as opposed to paying the physician. Your audit attribute list will also look a little different from the other physician arrangements that we mentioned previously. So we've provided a list here of possible audit attributes that you might consider for a physician lease audit. This is also one of those audits that you can't really do sitting behind a desk. You have to actually walk the space that's being used, or you'll miss some of the highest risks in this type of audit. And with that, let's jump into our final polling question. Amy, do you want to tee us up for that?
All right, so our last question is, how would you rate your physician contract auditing program? And you have strong, moderate, weak, unsure, or an A. And I know we have some questions in the Q&A log, so we can use this time to get to some of those.
Yeah, I'll hand the first one off to Larry on annual limit. Do you want to answer that one?
Sure. Yeah, happy to. It's a really good question. And the question is, what is the annual limit for gifts, lunches, etc. for home health referral sources? And the reason this is such a great question is because the person who's asking knows that home health services are on that list of designated health services. It's always one of those things you ought to be checking for purposes of your audit is, this goes along with Jim's excellent remarks a minute ago, that you need to not only know that you have a physician who's been making referrals for purposes of STARK, or that they're referring DHS. So physicians who don't refer DHS don't trigger the STARK prohibitions. But the question also talks about referral sources generally, and it's not limited just to physicians. The STARK rule is limited to just physicians and immediate family members of physicians. So referral sources other than physicians, that annual limit doesn't apply. So now let me answer the question. The answer is $429. It's exactly the same as all the other DHS entities that could take advantage of the non-monetary compensation exception. This is different, by the way, from the medical staff incidental benefits exception, which allows that $37 lunch, and it does not have that annual cap. But the medical staff incidental benefit exception only applies for hospitals, doesn't apply for home health agencies, so no help for you there. I also think that I would have to note that this non-monetary compensation exception and the auditing that we were just talking about only protect you from STARK law liability or physician self-referral law billing prohibitions. They don't apply to the Anti-Kickback Statute. As I said before, there is no de minimis limit for anti-kickback. So in those situations where you have, in this question, lunches, gifts, etc., you have to have a facts and circumstances analysis to justify those services, those benefits at all. I don't know if Lori or Jim or Calvin wanted to add to that.
I was going to add, I'll add to it, and I think things about annual limit for those non-physician. We have talked with various clients about setting some type of dollar limit. Closest we could come to is some of the IRS rules and things like that. So if you're giving it to, let's say, a facility that isn't a physician, you may want to set that so that it doesn't look like you're one giving unfair dollars to a different organization from another, a variety of things that could come in place, although it's not legal. It's just making sure that you have a reputational risk. So,
agreed.
Their input on that one. We'll look at our responses. Like we have the physician contract auditing program that we have an unsure is taking the high score on this one. So probably time for some of us to go back and look at what the physician contracting program is and maybe even start doing your probing auditing and interviews to find out how it's organized and how it's tracked.
Yep.
So with that,
you just got a great example of how to do it.
Yeah, exactly. Jim had a very extensive detail, and he actually has a really nice article that supports that particular slide deck that he just went through as well. That's available on HCA. So from a conclusion, I kind of look at all the regulations as like not just we used to say three-headed monster with STARK, anti-kickback, and false claim, but it really feels like a really large squirrely monster with lots of different arms and things to think about. You know that the government enforcement's vigorous and they're looking at these things. There's large fines and penalties. And I think really the key here is having that strong control environment in place related to decision contracts and payments, and making sure you have the right people looking at those controls and not circumventing them or saying, oh, that's just one extra thing to do. and make sure there, if anything, you have a really strong contract database, because much of what Jim was referring to is so much easier if you have a really good, strong contract database or tool to help you with that. So now we're going to take the remaining time to answer some questions. Calvin, do you want to respond to the question about how often should fair market value and commercial reasonable analysis be performed?
Well, I can definitely start the discussion on that. I think that's a great question, and I think one of the things I would point to is something that Jim raised also. I think I heard Jim say that most contractual relationships might have a year built into them, and that's something we often see is a year sort of as a starting point. Then there may be provisions that allow that to continue to auto-renew. It may include some language with regards to how to think about what that payment might be in the future. There's not a hard and fast set of rules around when to look at these things, but we often think that at least annually as that contract renews, it may be worth looking at if there's a significant change in the organization or structures or other things that might trigger an event where you need to go back and look at it. It may be worth it. But I know I've dealt with situations where those types of relationships have continued for a handful of years, 2 or 3 years, and then they realize that there may be something within the arrangement that they had originally entered into that may need some changes to it, and then we've been able to come in and help reassess at that point and look at things and make sure that whether it's still in compliance or whether it's a time to think about making some changes. Larry, I don't know if you've got anything to add with respect to that question.
I agree. I agree with what you just said. I read a lot of valuation reports because I don't get out much. But every time I do, I will see that they expire by their terms, that the evaluator will say that this valuation is good for 2 years or maybe 3 years. I'm not sure if there's an industry standard on that. And so if you're reliant on evaluation for a high value contract, sticking with their timetable has always seemed prudent to me. But I would also say that there's no such rule. There's no requirement to have valuations. There's no requirement to have a third-party evaluator to verify your FMV. But it's certainly prudent because then you have a good way to document how you got to that point. I think, Calvin, though, your point was well taken that if you're not relying on those valuations and you are using some sort of external approach to doing so, being aware of what the general market values are. If you're talking about rental of office space in New York City, this year the rates are coming way down. So if you're renting office space from physicians, you probably do need to revalue them if they come due in 2020 or 2021. So I thought your points are extremely well taken.
Thank you, both of you, for answering that question. It looks like we're about out of time. I do want to mention that for the hospitals on the phones, be sure to check out our complimentary analysis related to reimbursement. It's our reimbursement enterprise consultants have a tool that'll let you look at the reimbursement. So if you get a chance, you can go to our website and look at that. And then I'm going to hand it off to Amy to finish out this, and we will follow up with all the remaining questions on the list and let you with each of you to let you know what the response to that would be. Amy?
All right. Thank you, Lori. And thank you, Lori, Jim, Larry, and Calvin for a great presentation today. As a reminder, if you attended today's presentation in a group and would like to receive CPE credit, you must complete the group attendance sheet found in your console. If you participated as an individual and met all requirements, your certificate is available to download now in the CPE progress window. I will keep the console open for a few minutes to give you time to download, and a copy will be emailed within 3 weeks should you have any difficulty downloading it now. And here is a link to an online survey for today's presentation. Please take a moment to complete this survey as your feedback is very important to us. And thank you for joining our webcast. We hope you'll join us again next time.